So my name is Muhammad Alam, and I am a senior barrister and senior lawyer, and also the founder of Alam Law. We are personal injury and insurance litigation lawyer, as many of you know. We have lawyers at our firm who do civil litigation anytime that somebody is suing you or you would like to sue. I supervise the civil litigation sections as well. But we have a specialized lawyer in that area of law. Today, I'm going to talk about what is mediation and what is arbitration in the context of a civil litigation. Now, many of you would know civil litigation, but many of I anticipate that they would not know what does that mean, litigation. Litigation means a civil dispute that you have with another person. So either you have a civil claim, a claim against, you have given loan, you have started a business, there is a dispute. Any time that you have a civil dispute, business dispute, property issues, you bought a property, unable to close, somebody is suing you, or if you are the seller, the buyer did not close, you have to sue the seller if you have suffered some losses. So that's called civil litigation. Now, in the context of civil litigation, today I'm going to talk about the importance of mediation and arbitration. So before I start even talking about, I would like to share with our viewers that I am not only a senior lawyer, but also a qualified mediator and also a qualified arbitrator. And in a second, I'll tell you what does that mean. In majority of the civil dispute, mediation is a process where I encourage most of our clients that rather than jumping into in a civil matter and taking the matter to the court, depends on how big the dispute is. Let's take an example. If your dispute is about $50,000 or $70,000 and you want to sue somebody because that person did not pay you money, that person may have some other story about why he believed that he does not owe money to you, because he may have some other, other reasons for that. And mediation is a good process to be engaged in when you have a claim of, that nature. When you have a bigger claim, you can directly start a civil case to recover of your, although even on those cases, this is also a good advice to engage the other party into a mediation, and your lawyer can do that. Because why mediation is better for those disputes? Because it's number one, it doesn't cost you friction of the money that you will be spending into a lawsuit. I can give you an example for a civil lawsuit in the Superior Court of Justice. Depending on the complexity of the file, it could be anywhere from $50,000 to $100,000 or $150,000 legal battle that you will be. So a $70,000 dispute really does not justify a lawsuit to start, but you can engage, hire a lawyer or a mediator who can engage in, the other party into a mediation process that will cost you very little money, $1,000, $2,000, $3,000, and bring both parties to the table. And many disputes generally settle at that level. But if for any reason other party is not interested to engage in mediation, then there is another option available for the litigant. When I say litigant, means a person who has a claim who wants to sue the other person against that person if you believe that you have a claim. So both litigant can also choose arbitration route, because arbitration process is the same process as you will go in civil court. But when you go in civil court, every document, every information, every witness, every document you submit, it's all public. There are certain disputes that you would like to keep it confidential. In those cases, I suggest an arbitration will be a better route, because arbitration again is fast, efficient, and you can get the result that you are going to get result from a judge at the Superior Court of Justice. But again, there are mediators available, but you have to ensure that you choose the mediator who has experience in that kind of dispute or who has experience in those kind of litigation. Similarly, as I said, like if you have dispute, go to court, you spend $50,000 or $100,000, but there are times, as I said, like you want to keep some confidentiality. When you engage into an arbitration process, both parties and their lawyers will agree to an arbitrator like me or many other arbitrator who have experience in the area of dispute, who can deliver you the result. The arbitration process is the same process as a judge will do. The arbitrator will hear all the evidence, and at the end of the day, the arbitrator will deliver you a decision. The other important point is, because arbitration, choosing arbitration will be better for you for dispute, because to challenge the arbitrator decision is difficult, as unlike in court, because if you are not happy with the decision, you can go for appeal. Just because you believe that the judge or jury, they have made error in law or facts. Arbitrator decision is not generally being challenged, only on exceptional circumstances. So that gives you a finality, and most of the businesses, people who are in business, they should consider arbitration rather than going to court, because litigation, as it drains your energy. You will spend a lot more money into litigation. Still, outcome is unpredictable. So you should always consider, if you are in litigation or at the initial stage of litigation, if you have hired a lawyer, consult that lawyer. Seek your lawyer's advice about going through mediation or arbitration before you start a lawsuit. But if you have any question or a follow-up question on today's topic, you feel free to call me at the number provided on the screen. Myself or one of our lawyers will be able to guide you and give you the answer. And as I stated earlier, that we always, depends on the nature of the case, depend on the amount in dispute. I always encourage people to consider mediation or arbitration route rather than spending money, your hard-earned money, to the legal fees, and at the end of the day you may not get all the money recovered from the other party. With that, I thank you for watching. Thank you.